Morning everyone, and welcome to Construction Cast. This is our final episode of the year. We're looking at variations this morning, and we've got three speakers joining us as usual. As usual, we'll be half-hour chat with questions and answers at the end. So do put your questions in the chat as we go along, because we'll be taking them from you at the end. So without further ado, I'm going to introduce our speakers for this morning. So we have with us Andy Hewitt, who is a director at Dubai-based consultancy Hewitt Decipher Partnership and the founder of Claims Class. Andy's been working in the construction industry for over 40 years and is regarded as a claims specialist. As well as helping clients avoid and resolve construction disputes, he's also written numerous books on construction contracts and claims. And we've got Michele de Gregorio, who is a barrister at Crown Office Chambers. He's described by Legal 500 as immensely hardworking, very bright and an excellent lawyer. Michele has extensive experience in construction litigation, as does our third speaker, Suzannah Fairbairn, who is a senior partner at Dentons in Dubai. Suzannah is a member of the construction dispute resolution team and practices across the Middle East. She typically acts for employers, contractors, developers and project companies. So we're going to kick off. This week we are looking at the subject of variations. So coming to you first, Andy, what is a variation and why are they such a difficult topic for so many people?
Well, a variation is basically a change to what the parties, the contractor and the employer, and forgive me, I will use the impression employer instead of client or owner, and engineer instead of architect or contract administrator. But between the two parties, it's something that's changed at the time they entered into the contract. So this could include changes in the quantity, so you're doing the same thing but you're doing more of it. So instead of 100 houses, you're going to build 105 houses. Changes to the quality, so the quality is inevitably written down in the specification or in the employer's requirements on a design and build project. So the employer, the engineer, decides he wants something that is usually an enhanced quality. It could also be changes to the levels, positions and dimensions of the project. So we think about this in terms of something like a pipeline project. It was originally 10 kilometres and now because of rerouting, it's now going to be 12 kilometres. And that extra 2 kilometres and the rerouting could take it through more difficult terrain, require us to dig deeper trenches, etc., etc. It could actually, because generally we think in terms of variations of additional work, which cost more money, but it could actually be omission of work. So we've got our contract to build 100 houses. Maybe the employer decides that he only wants 90 houses. So we've omitted 10 houses. Or it could be occasionally changes to the sequence or timing of the work. And I can only think of one example on projects that I've worked on, which was an airport terminal in a live airport. And the contractor originally envisaged to build the terminal, if you think about it as a finger sticking out from the hub to the end of the terminal. But because of operational challenges, i.e. they needed to bring the new Airbus in and the gates were at the last end that was going to be constructed, they decided to build it from the outside and work towards the hub of the airport. So that really is what comprises a variation. Why do they cause so many issues was the second part of your question. Well, as with most things, the employer doesn't want to allow any more time for things that have changed, and he doesn't want to pay any more money for his project. So there's inevitably going to be a pushback from the employer and the consultants, in Fiddick's case, the engineer. And another reason why it tends to cause contention is because the contractor, having got entitlement to a claim, maybe that's not been acknowledged, doesn't do a very good job about claiming for the variation, about explaining why it's a variation, why it should delay the time for completion, and why it should be entitled to additional payment for that variation. So inadequately expressed claims is another very, very big reason for causing problems.
Coming to you, Michele, what do the various construction contracts say about variations? Are there any differences we need to look out for?
So Annie, there are a number of differences, and I suppose you can think of it as at one end of the spectrum, you've got lump sum contracts where there's very little scope for contractors to have additional cost and time for changes. And at the other end of the spectrum, you've got remeasurement contracts where there's far more scope to assess what actually the work that was actually required as the project panned out. So generally more favourable to contractors. The first point is one of terminology. Some different standard forms adopt different terminology for variations. The JCT Design and Build 2016, for instance, refers to variations as changes, and the definition includes changes that are instructed, and also other matters which are to be treated as or requiring a change. That, from experience, is often the nub of many disputes, where something happens on site or some external event, such as a decision by local authority, building control, or various other matters, require the works to differ, and the parties argue about whether that is a matter that constitutes a change or should be treated as a change under the contract. The various standard forms, and sticking with the JCB Design and Build, require notice to be given by a contractor of matters that are going to result in a change to time and cost. And in that standard form, notice has to be given forthwith. Other standard forms adopt different time periods. Different other JCT contracts, for instance, the with and without quantities standard forms are lump sum contracts. So there's far less scope generally for additional work to be treated as a variation, but it's still possible if it falls within the definition of a change. Moving on to the NEC3, the terminology here is compensation events, and they're listed. There's a long list in clause 60, depends which version you're looking at. The first is, well, probably the most important from today's purposes. It's where the project manager gives an instruction changing the works information. And the requirement is the project manager gives instruction. So one does have to look out on a project not to take instructions directly from the employer for matters that might be changes, because that won't constitute or won't fall within the contractual mechanism for a compensation event. The other point to look out for when signing up to and entering into the NEC3 is to make sure that the accepted programme contains everything that the contractor needs from the employer, and the dates that is to be provided, because certainly in terms of time, if there's a delay in providing information, then that can sound in additional time, but it won't do if you haven't specified it. We're moving away slightly from variations there. Other variations, other consideration is emissions, and can an emission amount to a variation? Well, it can, obviously, and there's a recent decision of the Scottish House, Scottish Court Session, the Outer House, I should say, in Van Ord and Dragados, very recent in October, which was an NEC3 contract, subcontract, and the contractor omitted certain works from the subcontractor's scope. Interestingly, it was found to be a breach of the subcontract to give that work to another party. Generally speaking, an omission won't be a breach if it's a decision by the employer that they don't want certain work carried out. But if they want to give the work to a third party, then that's a different matter altogether. In that case, it was decided that that resulted in a reduction to the defined cost under using the contractual mechanism, which some may think is a slightly unfair decision for the subcontractor, rather than the alternative, which may have been a finding of damages for the breach. Moving very swiftly on, FIDIC, various iterations. The Red Book is an example of a remeasurement contract. So generally speaking, contractor will take less risk on variations. It does contain, which is common to a number of standard forms, fairly strict condition precedent in terms of extra time and cost, clause 20. The requirement is strict. Typically condition precedents such as that are construed fairly broadly, but if you're required to give notice, and that is a condition precedent, then you need to be particularly alive to that. And I think Andy's going to talk later about when one should be giving notice under these, under such provisions. And the ICC contains also, similar to the NEC3, an early warning provision. At the heart of that contract, of course, is collaboration, and the requirement to give notice as early as possible, a common theme. In terms of variations, these are required to be ordered by the engineer in writing, and as with other contracts, that's often a fruitful source of dispute, where an oral instruction is given and it isn't later followed up. The contract permits it to be followed up within 2 working days in writing. And if that's not done, where do the parties stand? And then finally, bespoke contracts, which can adopt some or a combination of the provisions from the other contracts, and common in the bespoke contracts, certainly in Middle East and other jurisdictions, are strict notice requirements and worded as condition precedents to payment for extra work. And I think Andy as well may be answering a question later on what one does if no formal instruction is given for extra work in those circumstances.
Thanks, Michele. Suzannah, come to you next. Do you have to comply with a variation order?
Okay, yeah. So this actually often isn't an issue for us, because usually, assuming it's a variation for additional work, the contractor is often glad for the extra work, as long as they're going to be fairly compensated, which as long as it's a variation properly issued under the contract and everyone follows the contractual mechanisms for valuation, then they should be. Having said that, there might be very good reason why the contractor doesn't want to comply with it. They might have another job lined up afterwards, or don't have the resources available to comply with it, or it might be an omission of work that they are keen to carry out and be paid for. So I'll quickly run through, there's 5 potential areas where you may not have to comply with it, or considerations at least. So firstly, consider whether the engineer has the power or authorization to vary the works. I should say that I'll focus mainly on the FIDIC Red Book in this, because I'm based out in the Middle East and that tends to be the form of contract that we use. So Michele in particular, feel free to jump in if there's any significant differences in the UK standard forms. But so in the standard form, the engineer does have power or authorization to vary the works. In the Middle East, that's often amended so that the engineer needs the employer's authorization, particularly if the variation is over a certain amount. So just check whether that is the case in your contract. If not, if the engineer doesn't have the power to vary the works, then you probably should not carry out the works unless or until the proper authorization is given from the employer. Second consideration is, has the engineer fulfilled the variation provisions in the contract? So if the instruction needs to be in writing, again, if not, then don't undertake the works unless or until those provisions are fulfilled properly. Otherwise, you'll be at an increased risk of non-payment. Thirdly, there is an option in the FIDIC Red Book, at least, for the contractor to promptly give notice that they can't readily obtain the goods that are needed to fulfil the variation. And goods has quite a wide definition, so materials, equipment, machinery, etc. Oddly, though, that doesn't necessarily get you out of undertaking the variation, even if you do say that you can't readily obtain the goods. The engineer then has the option to cancel, vary, or confirm the variation. Obviously, though, if they do confirm the variation, once you put them on notice that you haven't got the goods readily available, then the engineer should be on notice that that variation is likely to be costly, and again, follow that up with the necessary notices to make sure that they're aware of that before you carry out the variation. Fourthly, the scope of the variation. So in FIDIC Red Book, there's a list in clause 13.1 of what, or examples of what could constitute variations. That list is not conclusive, but it doesn't appear to envisage a substantial departure from the original scope of the variation. So if it's a completely different scope to the original contract works, then there might be room to argue that that's not a variation as envisaged under the contract. And then finally, just consider if it's just a request from the engineer for a proposal, which would be under 13.3 of the FIDIC Red Book, then you're not obliged to carry out that request. You're just obliged to respond or to explain why you can't respond.
Okay, thanks for that. And Andy, what about in those situations that Michele referenced earlier, perhaps where you don't receive formal notice, or it's an oral instruction, or from the wrong person?
Yeah, I mean, this is a very, very common occurrence, in an ideal world, of course, you know, the engineer, the architect, the project manager, the CA, or whoever would say, Mr. Contractor, here's a formal variation order. Don't do it like that. Do it like this. And of course, we'll pay you for doing it and give you an extension of time if this delays the time for completion. But as we know, we don't live in an ideal world. And as we also know, not all engineers, architects, contracts, administrators, etc., perform their obligations fairly or impartially, or in the way that the contract says they should. And as we also know, employers don't like giving any extra time or any extra money if they can absolutely help it. So it doesn't always happen that the engineer will say, here is a variation order, Mr. Contractor, please go on and do it this way. And examples of these are, they can just issue revised drawings with the status issued for construction. Under FIDIC, as Suzannah alluded to, the contractor is obliged to take instructions from the engineer. So if he issues revised drawings, that's akin to having an instruction, build it like this, but there's still no acknowledgement of a variation. There could be comments on the contractor's design in a design and build project, or on shop drawings when it's not a design and build project, but the contractor is producing shop drawings for the detailed design. Same thing, comments on material submissions. You know, we don't want this standard of whatever it is, we want something different. Responses to requests for information. You know, when the contractor said, the drawing says this, the specification says something else, which do you want? And inevitably, engineer will say the most expensive option, of course. It could be instructions on site. You know, when the guy on site is flexing his muscles and he says to the contractor, don't dig the trench there, dig it over there. Or don't put the pipeline. So there are a lot of examples where formal variations instructions are not issued. And what should you do when you don't receive a formal instruction acknowledging a variation is always, always, always immediately give a notice or a letter, depending on the particular form of contract, to say, dear Mr. Engineer, we consider that your instructions to do this, that, and the other comprises a variation to the contract for which we will be entitled to additional time and or additional payment. Unless you advise us within the by return, we shall carry on with the work. Slightly different to where Suzannah's way of thinking here. I used to be a project manager, so I'm looking for reasons to do things rather than reasons not to do things if I was wearing my contracts and claims expert hat on. But unless you advise us by return, we shall carry on the understanding that this is a variation.
Okay. Coming back to you on question we've got about what powers do courts and tribunals have to determine CA certificates if the parties have made a contractual agreement that such certificates will be final and binding?
I think that's the question for me, is it, Annie?
Yeah.
The short answer is very little. Fairly tightly circumscribed power. If the contract does in fact provide for a certificate to be final and binding, and one has to look at the particular wording because it's not always obvious. Fairly clear words are needed to have that effect. But if that is the effect, then one is limited to challenge on the basis of fairly exceptional circumstances such as fraud, collusion, dishonesty, want of jurisdiction, and so forth. So fairly limited scope and generally a high hurdle to challenge a certificate that is truly final and binding. One other point is that occasionally there are, or the contracts provide for the ability of parties to challenge a certificate before it becomes final and binding, and that will usually be within a tightly defined time frame. So that is something that one needs to be alive to over the course of a project. If there's a certificate that's adverse or that has the potential to become final and binding, then go and seek advice, or if necessary, and take the steps required to protect your position before that happens, because otherwise it can be very difficult indeed to overturn and open up such a certificate. And as with other things, there's a trade-off here between the certainty that final and binding certificates provide on a project and the lack of flexibility and potential injustice that can cause if the parties are stuck with it. Because even if there's a substantive error in a certificate, if works weren't in fact extra works and they've been certified as such, or even if they weren't done, that sort of error is not the kind of error, generally speaking, that can be give rise to a certificate being opened up in those circumstances.
Thanks, okay. And then finally, before we move on to questions from the audience, we're just going to talk a little bit about notices, because they seem to give people a lot of problems. Andy, when do you submit a notice? Before the variation is agreed, when you start carrying out the works, at the end of the project?
Well, before I answer the question directly, let's just have a think about why contracts put such importance on the submission of notices from the contract. Well, not only the contractor, but from all of the parties. But in this case, in the case of the contractor, as Michele said earlier, under certain contracts, the submission of a notice of intention to claim is a condition precedent to entitlement. So if you don't submit a notice within a set time frame, in the case of FIDIC, it's 28 days, you can't have anything. Tough luck, bye-bye. Yeah. So why do contracts place such importance on it? Well, the answer is very simple. And contractors, please try to see it from the engineer's, the employer's point of view. Let's take an example where the engineer's told the contractor to do something, and the contractor comes back and said, that's going to delay the project, and we need additional payment for doing that. Now, this allows the engineer stroke employer to say, oh, we didn't realize there'd be a delay, and we didn't realize that it would cost us additional money. Let's not do that. Let's go back to what we were going to do. Or it could well be, well, we need to do it. We didn't realize there was a cost and time implication. So before you do it, before we confirm the instruction, give me an estimate of what the delay would be and what the additional payment would be. Or finally, what the contractor's done is made his position clear. I consider this is a variation, I want time and possibly more time, and I want more money from it. And if the engineer's not contradicted that, or given rescinded the instruction or given an alternative instruction, the contractor's got the comfort then of going forward to say that the principle of the variation has been agreed. So, when do you submit the notice, which was the original question? And my answer to that is absolutely as soon as possible. As soon as you are aware of the event. And if you've got any doubts about whether to submit it or not to submit it anyway. It's very, very easy later to say, look, we've had a look at this. We've looked at the contract in a little bit more detail. We've done a quick delay analysis, and we won't be submitting a claim. We won't be wanting additional payment. That's a lot easier than trying to argue with Michele and Suzannah in dispute proceedings. Well, we didn't submit the notice because we forgot about it, we didn't think it was necessary, or we didn't realise that we should have submitted it. So there you go. That's my advice. As soon as possible, and if in doubt, submit anyway.
Thanks, Andy. And I suppose, that's best practice when we're going forward. But Suzannah, what happens when we get to the end and we realise we haven't submitted the notices adequately? Is all lost for us?
Yeah, I mean, I think Andy has largely answered that question for me already. The answer is make sure you do submit the notices during the project when you need to, in accordance with the contract, particularly if, as in FIDIC, it's drafted as a condition precedent to a claim. If it is, really there's very little that you can do if you reach the end and realise that you haven't submitted those notices. You can, of course, go back, check through all of your correspondence, see whether there's anything that you did submit, any letters that you wrote that could be classed as a notice, that you can argue after the event, we raised this, we brought this to your attention, you're aware of it. But really the take home is, do make sure you comply with the notice provisions.
Thank you.
There is another option there, if I can just butt in. Contractors, once you've dug yourself into that hole, your other option is to come and see Michele, Suzannah, or myself, and we'll try to get our best to get you out of it. But the best form of prevention, a cure, is prevention, and don't dig yourself into the hole in the first place.
Thanks. Right, we've got some questions coming from the audience that we'll take quickly before we move on for today. Our first question says, as a matter of principle, do the speakers consider that otherwise valid variations can be time barred by strict conditions precedent? Anyone have a view on that?
I mean, as a matter of principle, it probably is just, but it certainly feels very unjust and unfair to the party who is barred. And the justice is one of it's one of the system itself, and as ever, it's a trade-off between the certainty that having a strict condition precedent provides to both parties, because they know where they stand on the project, and the injustice and disadvantage that the party suffers if they fail to comply. But the system overall, I think, is justifiable, provided it's, if it's even-handed and has to apply to both parties equally. If it's one-sided, of course, then it would be rather different.
Thanks. Question for Suzannah. Clause 1.3 of the FIDIC Red Book states that a notice or any other form of communication shall be identified as such. In the case of an instruction from the engineer, is it a case that the instruction needs exact wording variation instruction? Or if it doesn't, and the contractor does the work, is the contractor entitled to be paid for additional work? So I guess they're asking, if you don't say this is a variation, is it a variation?
Yeah, so FIDIC Red Book is actually slightly confused on that point. So the definition of a variation in the FIDIC Red Book is, I think, a variation instructed in accordance with clause 13. but then the clause referring to engineers' instructions says that if the instruction constitutes a variation, then it shall be valued in accordance with, as a variation. So I think that the position is that it will depend on the substance of the instruction. So if the instruction is, as a matter of fact, a variation, then it should constitute a variation, and it should be valued as a variation. But again, as we've said, if you receive an instruction and you think it is a variation to the works, then write to the engineer straight away to confirm that that's the position.
Thanks, Suzannah. And our next question, perhaps I'll ask you this one, Andy. My experience is that contractors find numerous ways of getting around notice requirements. What advice can you give to employers to minimise this risk?
To employers to minimise the risk? Sorry, I don't understand that one.
When the contractor's claiming for variations.
So could you just give me the question again? Sorry, Annie.
Yes. Whilst the concept that is being presented, no early claim equals no payment, my experience is that contractors find numerous ways of getting around notice requirements. What can employers do to minimise the risk?
Well, I think the contracts themselves control the risk as far as the employer's concerned, because FIDIC, for example, is very specific when you should submit and also the JCT and NEC, although I'm not an expert on these contracts, but when the contractor should submit a notice. And in the cases of notice of entitlement to claim, it makes that a condition precedent. Yes, as claims consultants, we often have to support our clients who have not submitted the necessary notices. And sometimes we've got to be a little bit creative with the law under which to which the contract is subject to try and create a persuasive argument. But I think the employers really do, their protection is contained within the contract. One of the things that I've noticed that employers try to do, and I think it's done from the wrong intent right from the start, they will reduce the time frames for notices. So instead of 28 days, I've seen it reduced down to 7 days. What this is they're trying to do is think that the contractor will forget or he won't have time to do it. Therefore, we can time bar their claims. In actual fact, it might work with an unsophisticated contractor, but with any contractor that knows his contract, he will just send a notice for everything that happens. The engineer sneezes, there's a notice. You give me a new drawing, there's a notice. Yeah, because they don't have time to investigate the matter and say, is this a claim? Do we need extra money? Do we need extra time for it? So I hope that answers the question.
Thanks, Andy. And finally, our final question, perhaps Michele, you can take this one. In respect of JCT contracts and interim certificates, does the adjudicator have jurisdiction mid-contract to determine the scope of works included in a variation for the purposes of determining the monthly amount that should be certified for payment?
Yeah, I think I'd start with the adjudicator will, take it to first principles. When will adjudicator have jurisdiction? There would need to be a dispute, and there would need to be a dispute over the scope of work included in the variation. If that dispute's crystallised, then I don't see why that dispute couldn't be referred to an adjudicator. The decision, if a decision's made on the scope of the work in the variation, because it relates to an interim certificate, will only be of interim effect, and then there may be scope later on final account for looking at that again, but provided there is a dispute over it, and I don't see why that couldn't be referred to an adjudicator for a decision.
Thanks, Michele. Did you want to chime in on the question on employers as well?
I was just going to say, I understand where the question's coming from, and from experience, if you take the NEC 3, for instance, it does have very strict condition precedent requirements, but then it also has a get-out clause, which is if the project manager should have notified the contractor of a change but didn't. So the contractor will argue, well, no notice was given, but this is something you should have given notice of. And I can see that the employer in those situations is going to feel hard done by. In terms of how to get around it, that's a far more difficult point. I'm afraid I don't have any easy answers. Don't choose those particular standard forms, or pay a lot of money to have your lawyers draft very onerous bespoke contracts. But no, I mean, it's probably the reality is probably just a question of sound management on the project. Engage the right engineer and make sure that everything is done to maintain relations. Obviously, that doesn't always happen, and that's why we do the jobs that we do, and some of us very busy in them.
Thank you very much. I think that's all we've got time for. It's such a big topic to cover in just half an hour. We could probably go on for a lot longer. So kind of in summary for today, you know, when we're looking at variations, check your conditions precedent. Be aware that each of your contracts is going to deal with each one differently. Ensure the right person is issuing those notices and the variations, and make sure you're issuing your notices on time and when you should be. Big thank you to all three of our speakers this morning for joining us, and thank you to everyone who's joined us this session and all year for these Construction Cast events. Just before we go, I want to wish everyone a happy Christmas and happy New Year from Stuart and I at Limeslade, and hopefully we will see you at one of these next year, and maybe even in real life in 2021. So thank you all very much for joining us this morning. It's good to see you. Bye.
Thank you.